Today, we're going to be talking about, should I bring an advocate to my IEP meeting? Should I bring an attorney to my IEP meeting? And what are the roles of both of them? So let's take it away. First of all, let's talk about what is a special education advocate. There are varying rules around what a special education advocate needs to be based on the state. In Illinois, for instance, it is a very lax title that people can use. That's why we are constantly warning parents, please make sure that you are asking your special education advocate about their background, about their experience, how many cases they've been involved in, including cases similar to your own. This is such a complex area of law and human and child development and education, and even areas within education, such as reading, math, speech and language, gross motor, fine motor. There are so many important detailed areas in making sure that a child receives a free and appropriate education. So we highly recommend that you first and foremost find specialists that are experts in these particular areas. Before I move on there, Judy, Phil, anything you would add? Because I want to next talk about, when do you bring an advocate? When do you bring an attorney? And should you?
So when do you bring an advocate to your meeting? I'm going to focus right now on when do you bring an advocate for the first time? Frequently, parents will contact me and they're having difficulties. Usually what I try to do is give them the steps and the opportunity to resolve those difficulties on their own. It's no surprise that school districts don't really love having advocates in meetings, particularly if it's someone who is very experienced and very familiar with the laws and what they can and cannot do. Every district is different, just like everyone has their own personality. In some districts, it can become adversarial very quickly with an advocate present, even without good reason. In other districts, I think they do a much better job of working together as a team. I think what's really important in working with an advocate is that you find someone who is going to enhance your role as a participant in the IEP team meeting. If you're looking for someone to come in and stomp their feet and really try and agitate the team, that's really not helpful or a very good way to go about getting what you need for your child. That's really what we should be focused on when we go into an IEP meeting, is getting what the child needs. You really don't want this to be adversarial. If you're working with an advocate and things have gone adversarial, you've reached that point where perhaps you do need to bring an attorney in, or you need to really look at what your advocate is doing and are they being effective for you? The goal should always be to get the team to work together. I tell parents basically, try and resolve it. If you can't resolve it, come back to me and I'll help you resolve it. Advocates can work directly with the parent by attending meetings. They can work in the background by ghostwriting emails and complaints and that kind of thing, and preparing parents for meetings. Most of the time, I would say parents choose to have me directly involved and working with the school. Once the school district or the LEA representative realizes that you just want to solve the problems and work together, it becomes a much more cohesive team, and a child is much more likely to walk away with the services and supports that they need, which again should be every parent's goal.
I'm paraphrasing what Judy just said. The advocate should not have their own agenda in this meeting or as part of their role. The agenda is the child in question. That's it. There may be a few side issues that affect the parents in some way that may come up that may be appropriate. But the goal, as Judy said, is to help the child get the services the child needs. It's hard because advocates are not licensed. They're not regulated. The federal law has some language in it about non-lawyers advocating, but it's pretty vague. It talks about experience and training. So you should feel comfortable asking an advocate what training they've had or what experience they've had in representing students with disabilities and parents. You have a right to ask that. You have the same right in terms of an attorney, but you should feel free to ask those questions. There are advocates that have good relationships with school districts and good reputations. Judy's one of them. Having a good relationship with a particular school district can help. Sometimes you have no control over that. Sometimes the advocate has no control over that, depending on who they're dealing with. So I wouldn't necessarily hold that against them if they don't either know the school very well or have some kind of an adversarial relationship because of some previous matter that they might have had. They should disclose that to you. They can say, I've had a bad experience with this district. I just want you to know that going in. Or I had a bad case with them 5 years ago, but we kind of smooth things out and I think we're okay. If there's something that makes you uncomfortable, you need to talk about that with the advocate in private and try to work it out because you're the one they're supposed to be helping. They're not supposed to be creating more problems. They're supposed to be helping you. One of their roles also is to educate you. So if there's something you don't understand and they can explain it to you, they can do that outside the meeting and say, this is what this provision means, or this is what this goal means. For instance, if there's a placement they're proposing and the advocate's familiar with it, they certainly have an obligation to try to explain and share information with you about that placement based on what they know. But that issue comes up a lot, and parents need help understanding the process. An advocate should play that role of helping them understand it.
I'm so glad you said that, Phil. Understanding your options. I always say you don't have to go mean. When the law is in your favor, you use the law. When facts are in your favor, you use the facts. They should be making it easier for you. Of course, there are some school districts that just make it difficult. There's no way around it. Or some district attorneys that get involved and they just make things more messy. There's no way around some of those people, some of those characters. But in my experience, and Phil, Judy, I'm curious to get yours, most of the time you don't have to get mean. You have to get smarter. I have worked with Judy consistently now for just under a decade, solely because of her level of expertise and how granular she understands the cases and their data, and then can zoom out and say, here's the picture. This is what it means for this child. These are the experts you need to pull in. Your advocate should be helping you figure out who are those right experts, who's the right neuropsych, or who's the right OT, or the right speech or reading, whatever it might be. Who are the experts I need to pull in to make sense of what's going on in my child's education to make sure that they can receive an appropriate education?
I agree 100%. You don't have to go mean, be respectful. And as Sabrina said, there are going to be situations where you have no control over what the district's response is. You can't control that. You can't to some level by being professional, being civil, stating what you need to state, making the points you want to make, and not getting personal, not getting angry, not stomping your feet. As Judy said, that doesn't work with most people. Most cases are resolved at the meeting stage. There are some where you hit a brick wall, you can't go any further, and you have to resort to whatever the procedural safeguards you choose to use, like a state complaint or a due process hearing. But most of the cases are resolvable through the meeting process. A good advocate definitely can facilitate those good outcomes. The other thing I think, Judy, you can correct me if I'm wrong on this one, because some people have different opinions than I do about this. Sometimes there are issues that you don't want to bring up. There are issues that you must bring up because they're urgent issues with regard to your child. There's some issues that could wait. And for the sake of resolving a matter, you might decide to wait on something a little longer to see how things play out.
Absolutely.
Go for the meat of your concerns and not some of the fringe issues that you may want to bring up. I have known advocates that have wanted to bring up every single thing under the sun. That their approach was every single issue, every single potential violation I need to bring up. That complicates the matter sometimes. Making the decision as to what is the most important, that's something you have to do with your advocate or your lawyer. For some people, they walk in and the placement is the issue. It's the main issue. It's maybe the only issue. Sometimes you can't resolve the placement issue and then you're stuck. The district wants to make a placement change, then you may get stuck in a due process without even wanting to be in one because that's the procedure. Most cases, again, can be resolved through the meeting process or one mediation session, going to state-sponsored mediation if you need. Most of the school district attorneys that I know want to resolve cases. There's some that don't try quite as hard to resolve them, but most of them do. Most of the school districts, at least the ones I've dealt with, would prefer to resolve matters rather than having them carry into due process or having complaints filed against them. Advocates play a very important role, though. If they do their jobs properly and really advocate for the child and what the child needs, they are hugely important. For one thing, not every parent's going to be able to find a lawyer to play this role. And when you bring a lawyer in, it means the district will bring their lawyer. In most cases, if you don't bring a lawyer in, the district won't bring theirs in at that point. But we go through that. We've talked about this a lot. At what point does the lawyer step in, assuming you can afford one or you can get one? There is such a thing as bringing a lawyer in prematurely.
It's a strategic decision on when to bring an attorney in and when to bring in a few attorneys. Sometimes you need to go big. It just depends. It's a strategy decision. And that's something that an attorney should do. When we talk about the different roles that they play, an attorney should help you navigate the strategy, understand your options. A lot of times I will walk through options that I don't think are very good for the client, just to say, look, you're the captain, you steer the ship. I'm just laying out the map to tell you where you can go. These are all your options. And these are some hurdles you're going to face. These are some of the wins. This is how much it's likely going to cost. This is how long it's going to take. And then leave it to the parents to make the decision based on their needs of the family, their resources, their time, all kinds of considerations. That's what an attorney should be doing. That's another good role distinction between bringing in an advocate versus bringing in an attorney. And sometimes you need both. Another way that I like to work with advocates is I ask Judy to read the record. First of all, it's a massive cost savings for the client. Second of all, she will see and understand things much deeper and differently than I will, because I have a different lens as an attorney than someone who's an advocate, and is deeper and closer to the kid, to the case, to the parents, sometimes to the providers and the specialists. Another role that an advocate can play is where you'll bring in an advocate to talk about placement or to talk about deficiencies in the IEP where they're an expert. There are some other areas that attorneys and advocates can play in your child's special education, and you as a parent or guardian understanding your rights, options, responsibilities, where the weight or burdens lie. A lot of times parents think they own responsibility that they don't, or they don't understand the ramifications of their child's rights. If their child has an IEP or a 504 or is entitled to one, is not receiving one.
Something that really struck me as both of you were talking, going back to how do you find an advocate and how do you decide if an advocate is the right advocate for you? At Breaking Autism, we offer a tremendous advantage in that I have all of you as a resource, whereas a lot of advocates, if they do hit a brick wall with you, if they don't have enough knowledge, if they aren't able to get movement, helping your child get what they need, they have nowhere to go. They have no resources. They're not in a network that's really a pretty small and tight network of special education professionals. And that's not to dismiss their abilities or anything like that, but this is a very complex topic, and you really need to ask those questions. What if we can't get anywhere? Then what comes next? They should be able to answer a question for you.
I agree. I'm glad you brought it up. This is an extremely complicated area of law. Questions come up all the time that people don't know the answers to, including advocates and sometimes lawyers. It's a pleasure working with Judy, and she knows when to ask the question, which is another sign of a good advocate, is they know what questions to ask and when to ask them. Some people don't. I spend most of the time that I spend on special education cases just backing up advocates, answering questions. I don't actually enter cases in vast majority of the cases that I get involved in. I may review documents here and there, but I don't have to enter an appearance or anything. There are questions that come up, and the advocates will call me and say, what do you think about this? Or what advice do you have to give, without me actually representing the family? These are really complicated cases in many instances. The law is complicated. It can be very tricky at times. Some of the questions that are posed don't have real easy answers. So I don't blame advocates for not knowing the answers, because sometimes we don't even know the answers. But they need to have, as Judy said, somebody to call to try to get an answer. That's hugely important. If worst comes to worst, you find somebody, know somebody at the State Board of Ed that they can answer the question of if they know the answer. It's real complicated. And my biggest fear is that there are situations where parents get bad information, not intentionally, obviously, being misled, but just get bad information and act on it and then end up with bad consequences for their child. We don't want that to happen. That should not happen. That's just my main concern.
Completely agree. Let me ask you this. Any red flags parents should look for? Advocate or attorney red flags?
Well, ask in advance. I've had parents that have called me who said, I have an attorney. They're a local attorney, and the only reason I know them is because they helped me with a divorce or something.
Bingo. They did my closing. They did my
They
mom's
did my
closing.
real estate closing. Right. Or my traffic court case. And you want to ask them, have they ever done this? A lot of the attorneys will just say, hey, I've never done one of these things. I don't know anything about special education. Try to find yourself somebody who does. In the meantime, I'll try to help you out as much as I can. Now that I can live with that. You have to ask. You're retaining somebody to do something for you in the legal arena. You need to ask the question about experience in the field, in this particular area. This is a specialty area of law that most lawyers are not involved in. Some lawyers can pick it up very quickly, but it's not easy if you're busy doing other types of practice or other things. You have to devote some time. The best approach is to actually work with someone who knows the area and do a case with them. That's the best way to work, especially in rural areas where there aren't that many attorneys. Sometimes you don't have a lot of choices. Sometimes it's okay to have somebody who's not quite as experienced in this area, but at least they're good lawyers and they can help you out in terms of arguing your points, but they may not even be able to identify some of the specific issues. But I get calls from lawyers too that ask me to help them through a situation. I had a lawyer call me who was a parent of a kid who had an issue, and I helped him through it. He wanted to do it himself, but he wanted me to give him backing. And I said, sure, I'll help you. He sent me the IEP and I gave him a list of questions to ask at the meeting. So all kinds of things that come up. My biggest fear is that people get bad information and then bad things happen. That's my biggest fear. But I'm always comfortable putting somebody in the hands of somebody like Judy or one of the other advocates that I know who have experience. They know how to work with schools and school districts, and they know how to read the documents and understand what the documents mean. That is huge.
I couldn't agree more, Phil and Judy. Thank you. Thank you for all of this. I know we have a lot more questions to cover, so stay tuned. We will be including more experts to come. If you have questions, as always, you are welcome to reach out to us at info@breakingautism.com. We highly encourage you to reach out. Let this be a guiding light. If you heard words here today that didn't make sense to you, or maybe triggered something, maybe there's something in your gut sparked, let that be a message and listen to it to research and learn more. We encourage you to also send us your questions. We want to hear from you because we are certainly not going to stop helping parents, guardians, and professionals. So with that, thank you so much for joining us, and we will see you soon.